I'm John T. Brady, an attorney with Vonachen, Lawless, Trager Slevin in Peoria, Illinois. For over 35 years, I've represented fire protection districts in central Illinois. I want to talk with you today about an important change in how fire protection districts must do business when purchasing goods and services. For generations, in most circumstances, Illinois fire protection districts have been able to buy items for fire department use without having to competitively bid the purchase of the items. While many fire districts have comparison shopped or used either a formal or informal bid process for some purchases, what is legally required of fire protection districts changed effective January 1, 2015. Section 11K of the Illinois Fire Protection Act now requires that most contracts for supplies, materials, or work involving an expenditure in excess of $20,000 must go through a competitive bidding process. While the statute says that it applies to all contracts, the Act does, in fact, exempt certain kinds of contracts from the bidding requirement. I'll talk about these exemptions in a few minutes. Unless one of the exceptions applies, if the Board of Trustees will spend in excess of $20,000 for a particular contract, here are the steps that the board must take to lawfully make the purchase. First, the board must advertise for bids. This ad must tell the reader what the fire district wants to purchase in enough detail to allow the potential bidders to know what their obligations will be if they are awarded the contract. The ad must also state the date, time, and place where the bids will be opened. The ad does not need to provide all of the information about what the fire district wants to purchase. Instead, the ad can refer to detailed plans and specifications about the purchase, as long as these plans and specifications are on file with the fire district at the time that the ad is published. This advertisement must be published at least 10 days before the date that the bids will be opened. When the 10-day period is calculated, Sundays and legal holidays are excluded from the calculation of the time period. Each bid must be sealed by the bidder. The ad for the bids should inform the potential bidders of this important requirement. Each bidder must receive at least 3 days prior notice of the time and the place that the bids will be opened. When it comes time to open the bids, each bid must be opened either by a member of the Board of Trustees or by an employee of the Fire Protection District. This must happen at a public bid opening. At the bid opening, the contents of the bid must be publicly announced. This must be true of each of the bids that are received. No bids can be received at any time after the time and date that was stated in the ad where the bids were solicited. Now, I said earlier that there are some exceptions to when trustees must follow the bidding process. The law sets out 10 specific types of circumstances where the bidding process that I discussed above for contracts in excess of $20,000 is not required. Generally, these exceptions are contracts that are not easily adapted to the competitive bidding process. Some of these exceptions will only rarely apply, such as contracts for the printing or engraving of bonds and tax warrants. These types of contracts are not something that most trustees have to worry about from day to day. Other types of contracts exempt from the bidding requirement will be more common. For example, contracts with a utility company to provide electricity to the firehouse, or telephone service, or water, for example, are exempt from the bidding process. So are contracts to let goods or services from another government agency, and contracts to purchase used equipment. Another important exemption is contracts for emergency expenditures. These are also exempt from competitive bidding, but this exception only applies in the event of a real emergency. However, this emergency expenditure must be approved by a vote of 3/4 of the members of the Board of Trustees. Imagine a situation, for example, where a firehouse has been damaged by a tornado and immediate repairs must be made to the structure to prevent further damage. This is the kind of situation that this exception is intended to address. There are other exceptions as well, and trustees should review the language of the statute in its entirety to determine whether of these other exceptions applies if the district will purchase goods or services in excess of $20,000. Further information about the bidding statute is contained in another video available on this YouTube channel. The above summary is intended only as an overview of the new law. The full text of the law can be found in the Illinois Fire Protection District Act at 70 ILCS 705/11K. While I hope that this information is helpful to you, it should not be considered as legal advice specific to your situation. As in all complex legal matters, it is important to discuss this new statute with an attorney who is knowledgeable about fire district law and how the law applies to your fire protection district. Thanks for watching. Stay safe.